Hi, Christine Faulkner with Cava&Faulkner, Elk Grove, estate planning lawyer, and we are here for another edition of Family Matters.
Hi, Christine. Lana Shearer here with Shearerlaw&mediation, also in Elk Grove, California. Happy to be here.
Wonderful. So today we are going to talk about guardianship, and there's a definite overlap between estate planning and planning for guardianship, as well as, of course, family law. And so I'll just get started with what I see in my practice and what I do. And so when I'm working with parents of minor children only, so if you have children that are adults, of course, guardianship doesn't come into play. But if I'm working with parents who have minor children, of course, we're going to be naming guardians in their estate plan. And I do something that's a little different than maybe other law firms, which is called kids protection planning. And so, of course, when we are creating the plan, we are incorporating naming guardians for the children until they reach the age of majority 18. Something were to happen to the parents, they pass away, or a parent, if the client is single, then we're creating guardianship documents that allow them to name the very best people that they feel would be a surrogate parent for their child if they were not able to be there. We also complete documents that allow the parent or parents to name short-term guardians, or what we call first responders, so that in the event of an emergency, not necessarily death, but say one parent was out of the country or out of state, and the other parent were hospitalized, that we are naming guardians for the short term that would be with the child or children for the hours or days until either the other parent could get back to them, or in the event of death, until the long-term guardianship could be sorted. And so many times I'll have clients asking, when we're naming people in our plan, what do we need to put in there? And, will our wishes be honored in our will or in these ancillary documents? So we actually have, beside the will, we have documents that are witnessed that allow the client to name both short and long-term guardians that are separate documents from the will, but they are also reiterated in the will itself. So they're both witnessed documents. And I often have clients asking me questions about, well, will our wishes be honored? What type of evidence what could happen if I have a single client, they're asking, well, what could happen if I pass away? Will the other biological parent automatically get guardianship, or if both parents pass away, say in a common accident, will our wishes be honored in our estate plan? And could there ever be litigation, or could there ever be like a contest? So what do you think about that, Lana?
So in cases of divorced couples where, one party wants to name a guardian in their will, the other parent would likely challenge that. And it's really the deceased parent isn't there to testify and try and, give reasons why that parent wouldn't be the natural guardian. Biological parent is the natural guardian in the eyes of the court. And unless there's good reason where, the health, safety, and well-being of that child are at risk, it being in the custody of this parent, then that would be the natural guardian. Actually, this came up recently. I had a phone call from a potential client whose daughter had passed away and left 2 minor children. And the father in that case, the custody orders were that the children were to be with mother, but he did have some type of visitation. So in that case, when she passed away, father called and said, I'm coming to get the children. And grandfather didn't want that to happen because really didn't feel that father was going to be a safe person to have custody of the girls. Mm. So I advised him that he would be wise to file in both family court and in probate court for guardianship of the girls, and then in family court as a grandparents petition for custody and visitation, because it's not really clear which path you should take. You know, you have a deceased parent, so probate court seems like a good idea. And then there's an active family case, so then family court for custody is also a good idea. So there's some competing interests, or not really competing interests, but sometimes the probate court and the family court aren't really sure who should have it either. So I've had cases where the probate court said, oh, this is a family court matter, let's go send it to family court. You go to family court and they're like, no, this is a probate matter, send it back to probate court. So that's why I advise that you just file in both courts and try and you know, follow both procedures and see which one that the court decides would be the proper path. But that's really difficult. It's hard to plan in your estate plan for guardianship of your children if you have another parent out there who has natural claims as the guardian, the biological parent. One thing that you mentioned was if you had a client, I think you mentioned it, but if you had a client that wasn't married, if the other, and so I'm going to assume this is the mother, because the mother is the only natural guardian. If you weren't married, the mother is a natural guardian until father's has been established as a biological parent. And in order to do that, that takes a filing with the family court. It's called a UPA action, a Uniform Paternity Act petition. And the father or the mother could file a UPA action in family court, and the court would make a finding that father is the legal father of the child. And then father would have rights to, you know, custody, visitation, and guardianship if the mother should pass away.
So I often tell my clients that when they ask these questions, that none of us, fortunately, my kids are over 18 now, so I don't have to worry about this anymore, but no parent has 100% parental rights, meaning your rights could be terminated as a parent if you were unfit. That's why we have CPS, right? That's why if there's some type of claim that you are an unfit parent, that, you know, so nobody has an automatic 100% guarantee of the ability to be the guardian for their children. But absent some, I would imagine, really egregious conduct, biological parental rights are always going to be superior to anybody else's rights. And many times when I'm working with clients who are divorced, or maybe they were not married, but they have some, you know, serious concerns about the willingness and ability and other characteristics of the other biological parent. When I'm creating a plan, they are very concerned, like, I really do not want this person parenting my children should I pass away, or should I become incapacitated, and what do I need to do to prevent that. And so, you know, we'll talk about unfit parenting in another video, but, you know, just talking about the kind of concerns that my clients have in general when I'm meeting with them for estate planning, the primary thing is, you know, will this ever be challenged? And especially if it's a married couple and they both passed away, because clearly if it's only one, then the other is the biological parent. So what are what's the likelihood that somebody could step up and litigate our decision making in our estate planning documents? And how does that look? You know, what are the criteria that a judge would look at or a judge in two different courts? What would they look at? What kind of evidence to determine who would be the best next guardian if it weren't the people that were named in the plan?
So they're going to evaluate the biological parent, and the goal is to find which guardian, whether it be a parent or someone else, is going to, you know, be in the best interest of those children. So, you know, which guardian is going to, has a bond is important, the bond between the child and another person. Hopefully there's a relationship, there's some bond. That's a really important criteria. But it's for their health, safety, and well-being. What person is competent and has the resources and the ability to care for the children, that's really important. And if your client that is drafting this wants to put a provision or, name guardians other than the other biological parent, I would highly recommend that they include some specific reasons in their estate plan on a separate document, an addendum or attachment that's signed, dated, witnessed would be a good idea, so that it can serve as evidence of the whys. And it should be specific. It should be this is why I do not believe the other biological parent is a fit parent, and that the children being in his or her custody would be in the best interest of these children. And it should be specific recollection of events, dates, times, because this is testimony that that parent would otherwise offer in court in a family law matter, saying this is why that parent shouldn't have custody of the children. It should be included in the estate plan as well. And again, the court is still going to look at it as it applies now, because clearly those documents have been drafted, previously. So the court is going to give that parent the opportunity to prove why now they are a fit and competent parent, and it's in the best interest of the children to be placed with them. But if you wanted to potentially, give some information, very clear, detailed information as to why the court should not make those orders, it needs to be carefully laid out. Just a general statement, that you don't want the other parent to be the guardian, or just naming other people, that won't be effective.
I know that many times my clients are, I'd love to talk about, like which court to file in, but I just wanted to say, and I know you can speak to that, which is, the better choice, or if you have to file two, how that works and the costs associated with both. But I know many times my clients are a bit squeamish, is probably a good word, to go into great detail in their planning documents themselves, where they're spilling the beans, kind of really going into the detail about why the other parent is not fit. And this is great information for me, because strategizing with my clients on how they can keep this information up to date, if it's truly important that the other biological parent not be part of the kids' lives, means that they're going to have to take it upon themselves, or we will have to confer periodically to determine if they can add additional, more updated information to kind of corroborate their continued wish and desire that the other parent not be a guardian because of ongoing behaviors that are not in the best interest of the children. So before we get into, I do have one question.
Yeah, I do want to comment on that before your question. Just it would be some evidence, those statements, including an estate plan, would be some evidence of the other party's unfitness, but it wouldn't be conclusive. So a court is still going to evaluate the situation, which is why it would need to be detailed, but it won't be conclusive. It won't, you still have to go to court and have a judge evaluate it.
Yeah. And so that kind of leads into my next question, like, what are the criteria? So if you're not talking about parenting, biological parent, but say you have, I have clients that I've worked with and something happens to both of them. And so both biological parents are deceased. How does a court decide when they have competing, folks on opposite ends of the spectrum vying for guardianship? What are the factors that a judge looks at? And are they different in family court versus probate court? What are they going to look at to make a determination of who would be the best choice?
Well, it's different from family court, because family court is going to be limited to the parents and then possibly grandparents, or sometimes there's a third party if the court, if someone petitions to join a family law matter. But if both parents are deceased, then it would be a guardianship matter in probate court. In the probate court, an investigator would be appointed. You have to make sure you're naming, all of the relatives and other people who might be potential guardians who have, bonds with these children. And then the probate court investigator uses the same standard as the family court investigator that we actually call family court service mediator. So there's probate court investigator, family court mediator. but their jobs are very similar. To see what arrangement, evaluate all of the potential guardians and see which one is going to be in the best interest of these children. So, and the best interest is really health, safety, well-being, mental health, physical health, who has the resources, who has the ability, and who has the bond with these children. And it's going to be in their best interest to remain with them. It's a really important process, and they will interview many different people. They do a lot of collateral contacts. That can include the teachers of the children, other important people if there's counselors involved, family members. It's can be a lengthy investigation, but their overall goal is to figure out what arrangement is in the best interest of the minor children.
So do they look at credit history? Does that ever come up?
There's not a question necessarily about credit history. They do look at, criminal background. There's a confidential questionnaire that the potential guardian has to fill out that includes, a little bit of demographic and history, and if you have any convictions, and if you, those type of things. But I wouldn't say credit history is one of them.
I mean, I know for bond, applying for a bond, your credit worthiness can come into play, but yeah, just a matter of curiosity. So I know that when I'm working with clients, in choosing guardians, there's a lot that goes into choosing the best guardians, and it's different for every client or every couple, but it's not uncommon for my clients to say, to choose mostly relatives, could be a couple or it could be an individual, but a real analysis of who are the people who share our values more than anything. We don't focus so much on resources. We focus on if our children had to be raised by other folks or another person who is the very best fit, who has the same kind of values, religious, money values, you name it, who's going to raise our kids in pretty much the same way. And it's a really interesting discussion, because there's usually people in the family that are fit that bill, and others who really do not. And so could those people who don't, who are not named in the plan, could they step up and still challenge the planning and say, we think we would be the best guardians because, even though they were not named in the will, and what are the factors that a court would look at there?
I suppose it's possible, but I would include information. If you have that detailed, discussion, you likely want to include information in the documents about why certain people who may be, a choice. If you think, okay, what are the possibilities if of all of these people, if they went into court, what are the likelihood that they would be chosen? Put your reasons why you consider these people and you didn't choose them, and why you chose the other ones as superior, because I think that's important. It's relevant. Again, won't be conclusive, but it's relevant, information for the court to have. That's the thing about the estate plan, right? Is you get to speak from the grave. You get to put your intentions. These are my wishes, and this is why these are my wishes. So I think that would be great information to include in there, because a probate investigator, they don't know, they're going to be evaluating people based on present circumstances. And again, bond is, probably key. Do they have a strong relationship with these children? They're going to interview the children. The children are, it's clear, from children who they have a bond with, and who, so that's really important.
Interesting. So what's the difference between filing in family court? You already mentioned a little bit, it's limited to certain, is it, parents and grandparents versus probate, everybody else? What are the costs associated with one court versus the other, and which has more priority? Which court?
So neither one has necessarily more priority, but they typically handle different types of cases. Probate would be guardianship, conservatorship, and then wills and contests. But in family court, we're dealing with the family unit, mothers and fathers, custody issues, And then grandparents, it's really custody and visitation in family court, and then guardianships in probate court. But sometimes you'll have, and this happens quite often, a grandparent who needs to step in as a guardian when both parents are not fit. And it might be on a temporary basis. Both parents aren't fit. One parent is incarcerated and the other parent is in a drug rehab. I had one of those. So during that time, the guardianship is they really only wanted it to be temporary. So you're going to go into probate court for the guardianship and handle it there. If there's also a family law matter, because this couple is divorced, sometimes the probate court will want to send it over to family court because there's an open family court case already. One of the reasons they want to do that is in family court, typically the investigation, there's not a cost associated with it. You pay your filing fee. You know, in Sacramento County, it's $435 for your initial filing fee. And then if you need to do some other motions, it can be a filing fee of $60 to $80. And then the family court service investigator is at no cost to the parties.
Yeah.
As opposed to probate court, the probate court investigator can be quite expensive, $600, $900. It can be expensive. So that's one of the reasons why, if you can handle it in family court, that might be a preferred way to do it for the parties due to the cost.
Yeah.
But you know, if it's strictly a guardianship then the probate court investigator will be the one that's going to handle it.
Excellent. Well, I have learned a lot and definitely have some new things that I can incorporate in my planning, and also discussions I can have with my clients about how they can keep their plans up to date without incurring any additional attorney's fees from me by having me update for them, but they can actually do that themselves. And I imagine make sure that it's properly witnessed. Or so just one last question. Do you feel there's a difference between having two disinterested witnesses authenticate a document versus a notary? Does it matter?
So I don't think it would necessarily matter, because in that case, they're not saying that this is truthful, you know, they're just witnessing that it was in their hands, you know. So I don't think that would really matter if it was a notary versus two disinterested witnesses.
But any kind of updated statement by my client should have a statement under penalty of perjury that the foregoing is true and correct, right? As
Yes.
you would in an affidavit.
Absolutely. It should be in the form of an affidavit, because this is evidence that you're going to want to try to introduce into court. And so as much authentication, original signature, dated, and under penalty of perjury would be most helpful.
Yeah. That was great. Thank you so much for that information. Really, really eye-opening and thought-provoking for new conversations that I can have with my clients. So thank you.
Great. Absolutely. Thank you. Very happy to be here.
Yep. And we will see you next time.
Thank you.